Whren v. United States, Supreme Court, 1996. Justice Scalia delivered the opinion of the court. In this case, we decide whether the temporary detention of a motorist who the police have probable cause to believe has committed a civil traffic violation is inconsistent with the Fourth Amendment's prohibition against unreasonable seizures unless a reasonable offer would have been motivated to stop the car by a desire to enforce the traffic laws. On the evening of June 10, 1993, plainclothes vice squad officers of the District of Columbia Metropolitan Police Department were patrolling a high drug area of the city in an unmarked car. Their suspicions were aroused when they passed a dark Pathfinder truck with temporary license plates and youthful occupants waiting at a stop sign, the driver looking down into the lap of the passenger at his right. The truck remained stopped at the intersection for what seemed an unusually long time, more than 20 seconds. When the police car executed a U-turn in order to head back toward the truck, the Pathfinder turned suddenly to its right without signaling and sped off at an unreasonable speed. The policeman followed and in a short while overtook the Pathfinder when it stopped behind other traffic at a red light. They pulled up alongside, and Officer Ephraim Soto stepped out and approached the driver's door. Identifying himself as a police officer and directing the driver, Petitioner Brown, to put the vehicle in park. When Soto drew up to the driver's window, he immediately observed two large plastic bags of what appeared to be crack cocaine in Petitioner Wren's hands. Petitioners were arrested, and quantities of several types of illegal drugs were retrieved from the vehicle. Petitioners were charged in a 4-count indictment with violating various federal drug laws, including 21 U.S.C. sections 884A and 860A. At a pre-trial suppression hearing, they challenged the legality of the stop and the resulting seizure of the drugs. They argued that the stop had not been justified by probable cause to believe or even reasonable suspicion that petitioners were engaged in illegal drug-dealing activity, and that Officer Soto's asserted ground for approaching the vehicle to give the driver a warning concerning traffic violations was pretextual. The district court denied the suppression motion, concluding that the facts of the stop were not controverted, and there was nothing to really demonstrate that the actions of the officers were contrary to a normal traffic stop. Petitioners were convicted of the counts at issue here. The Court of Appeals affirmed the convictions, holding with respect to the suppression issue that, regardless of whether a police officer subjectively believes that the occupants of an automobile may be engaging in some other illegal behavior, a traffic stop is permissible as long as a reasonable officer in these same circumstances could have stopped the car for the suspected traffic violation. Temporary detention of individuals during the stop of an automobile by the police, even if only for a brief period and for a limited purpose, constitutes a seizure of persons within the meaning of this provision. An automobile stop is thus subject to the constitutional imperative that it not be unreasonable under the circumstances. As a general matter, the decision to stop an automobile is reasonable where the police have probable cause to believe that a traffic violation has occurred. Petitioners accept that Officer Soto had probable cause to believe that various provisions of the District of Columbia Traffic Code had been violated. They argue, however, that in the unique context of civil traffic regulations, probable cause is not enough, since, they contend, the use of automobiles is so heavily and minutely regulated that total compliance with traffic and safety rules is nearly impossible. A police officer will almost invariably be able to catch any given motorist on a technical violation. This creates the temptation to use traffic stops as a mean of investigating other law violations as to which no probable cause or even articulable suspicion exists. Petitioners who are both black further contend that police officers might decide which motorists to stop based on decidedly impermissible factors, such as the race of the car's occupants. To avoid this danger, they say, the Fourth Amendment test for traffic stops should be not the normal one, applied by the Court of Appeals, of whether probable cause existed to justify the stop, but rather whether a police officer acting reasonably would have made the stop for the given reason. Petitioners contend that the standard they propose is consistent with our past cases' disapproval of police attempts to use valid bases of action against citizens as pretext for pursuing other investigatory agendas. We think our earlier cases foreclose any argument that the constitutional reasonableness of traffic stops depends on the actual motivations of the individual officers involved. We of course agree with petitioners that the Constitution prohibits selective enforcement of the law based on considerations such as race, but the constitutional basis for objecting to intentionally discriminatory application of laws is the Equal Protection Clause, not the Fourth Amendment. Subjective intentions play no role in ordinary probable cause Fourth Amendment analysis. Recognizing that we have been unwilling to entertain Fourth Amendment challenges based on the actual motivations of individual officers, petitioners disavow any intention to make the individual officer's subjective good faith the touchstone of reasonableness. They insist that the standard they have put forward, whether the officer's conduct deviated materially from usual police practices, so that a reasonable officer in the same circumstances would not have made the stop for the reason they give, is an objective one. But although framed in empirical terms, this approach is plainly and indisputably driven by subjective considerations. Its whole purpose is to prevent the police from doing under the guise of enforcing the traffic code what they would not like to do for different reasons. Petitioners' proposed standard may not use the word pretext, but it is designed to combat nothing other than the perceived danger of the pretextual stop, albeit only indirectly in over-the-run of cases. Instead of asking whether the individual officer had the proper state of mind, the petitioners would have us ask, in effect, whether, based on general police practices, it is plausible to believe that the officer had the proper state of mind. Why one would frame a test designed to combat pretext in such a fashion that the court cannot take into account actual and admitted pretext is a curiosity that can only be explained by the fact that our cases have foreclosed the more sensible option. If those cases were based upon the evidentiary difficulty of establishing subjective intent, petitioners' attempt to root out subjective vices through objective means might make sense. But they were not based only upon that, or indeed even principally upon that. Their principal basis, which applies equally to attempts to reach subjective intent through ostensibly objective means, is simply that the Fourth Amendment's concern with the reasonableness allows certain actions to be taken in certain circumstances, whatever the subjective intent. But even if our concern had been only an evidentiary one, petitioners' proposal would by no means assuage it. Indeed, it seems to us somewhat easier to figure out the intent of an individual officer than to plumb the collective consciousness of law enforcement in order to determine what a reasonable officer would have been moved to act upon the traffic violation. While police manuals and standard procedures may sometimes provide objective assistance, ordinarily one would be reduced to speculating about the hypothetical reaction of a hypothetical constable, an exercise that might be called virtual subjectivity. Moreover, police enforcement practices, even if they could be practicably assessed by a judge, vary from place to place and from time to time. We cannot accept that the search and seizure protections of the Fourth Amendment are so variable and can be made to turn upon such trivialities. The difficulty is illustrated by petitioners' arguments in this case. Their claim that a reasonable officer would not have made this stop is based largely on District of Columbia police regulations, which permit plainclothes officers in unmarked vehicles to enforce traffic laws only in the case of a violation that is so grave as to pose an immediate threat to the safety of others. This basis of invalidation would not apply in jurisdictions that have different practice, and it would not have applied even in the District of Columbia if Officer Soto had been wearing a uniform or patrolling in a marked police cruiser. In what would appear to be an elaboration on the reasonable officer test, petitioners argue that the balancing inherent in any Fourth Amendment inquiry requires us to weigh the governmental and individual interests implicated in a traffic stop as they have here. It is of course true that in principle every Fourth Amendment case, since it turns upon a reasonableness determination, involves a balancing of all relevant factors. With rare exceptions not applicable here, however, the result of that balancing is not in doubt where the search or seizure is based upon probable cause. Where probable cause has existed, the only cases in which we have found it necessary to actually perform the balancing analysis involved searches or seizures conducted in an extraordinary manner, unusually harmful to an individual's privacy or even physical interests, such as, for example, seizure by means of deadly force, unannounced entry into a home without a warrant, or physical penetration of the body. The making of a traffic stop out of uniform does not remotely qualify as such an extreme practice, and so is governed by the usual rule that probable cause to believe the law has been broken outbalances private interests in avoiding police contact. For the run-of-the-mill case, which this surely is, we think there is no realistic alternative to the traditional common law rule that probable cause justifies a search and seizure.